Hi, I'm Raymond Chandler, attorney at Polaris Law Group, estate planning law firm out of St. Charles, Missouri. Wanted to talk to you today about a topic that came up. It's the topic of married people, single people without any children. How do you estate plan for that? So how do you estate plan when you have no heirs? Well, first, let me get out of the way that you do have heirs, regardless of whether you have children or not, because the state law says where your property goes when you pass away if you do not have a plan, and that would be your legal heirs. And that chart goes all the way out to your eighth cousin or something like that. So without children, who would be your legal heirs otherwise, there are still other people who would receive your assets in probate if that's where you end up. But you want to avoid that. So the other question that comes up a lot of times is, well, if I don't have any heirs, I don't have any children, why do I need an estate plan? Because it's about who I want my stuff to go to when I die, and I don't care. Well, remember, estate planning is not just about where your stuff goes when you die. So let's talk about that a little bit. First, estate planning is about all four stages of your estate. Number one being while you're alive and well, how do we handle that? Two, when you're disabled, mental disability, how are we going to cover you there? The third stage being at death, avoiding probate and transferring your property. And that fourth stage that most people leave out, wealth reception planning, how are we going to plan for your assets to be given to whom you want, when you want, and the way that you want. So making sure that your assets and your property still do what you want even after you're gone. So looking at that for single people or married couples without children, how we plan around there. Well, really, a lot of times what we're going to do is we're going to focus a lot of our efforts on that second stage, that disability stage. Because even though you don't have heirs, don't have children you need to leave your stuff to, you still have you. And we still need to take care of you. And the way we do that when you're disabled is by planning ahead with a proper estate plan, making sure that you have your powers of attorney, your health care powers of attorney, maybe a trust, maybe some additional tools in that toolbox to make sure that if you become disabled that we can take care of you the right way and make sure that you get to name who those people are. So again, even worse is when you don't have the obvious choices of a child or a spouse or someone like that, then the courts are left trying to decide which niece, nephew, cousin, uncle, aunt is going to take care of you if you become disabled if you don't have a plan. So you want to make sure you have that plan ahead of time. You want to make sure you come in and do an estate plan to cover those what ifs in life, to cover if you become disabled, who's going to be in charge of you financially and legally, who's going to make health care decisions for you, all the way down to who is going to authorize pulling the plug if necessary. So on that power of attorney, you're going to want to make sure for the financial and legal side that you have somebody that you've chosen to be in charge of your finances and your legal. So paying your bills, cashing your checks, signing your contracts in and out of nursing home, dealing with your house, dealing with your investments, dealing with your taxes, dealing with everything that needs to be taken care of while you're alive but disabled. So while you're alive and well, you take care of it. And when you're gone, your will, your probate, or your beneficiary designations, or your trust will take care of it. But who's taking care of you in between when you're disabled? And then you've got the healthcare document that you want to worry about too, and make sure that you have somebody making healthcare decisions for you. What doctors do you see? What hospitals do you go to? What medicines do you take? What surgeries do you have? How aggressive of treatment are we going to have? All the way down to is it time to pull the plug? Now, those don't have to be the same people. They can be different. You could have one person in your life that's financially dependable and can pay all the bills on time and get everything accomplished that way, but doesn't have the emotional strength to make the medical decisions. Or maybe you're really lucky and you have the accountant friend and the nurse friend or the doctor friend or something like that, and you've got two perfect people that one person really knows finances and one person who really knows medical stuff. Either way, unless you plan ahead, they may not be able to take care of you. So you want to make sure that you sit with your estate planning attorney and talk about that disability section of how to take care of you while you're disabled. Because even if you have the point where you don't have any children, you don't have obvious heirs, maybe you're not even passing along that much stuff, where are we going to focus? And a lot of times we're going to focus on disability. Sometimes we can also use a trust during disability to make sure that all of your assets are put in a trust, properly titled, properly funded. Another issue there, and we've talked about that in some of our videos. But make sure that you have a trust that is properly funded and know who's going to take care of that when you're gone or when you're disabled. So during a time of disability, leaving instructions behind in that trust and leaving powers behind in that trust with somebody that you trust, know, and have nominated and written up ahead of time, you know who's going to be in charge of that. And so really when you're looking at estate planning without heirs, you really want to look at disability first. The next side of that is you do need to think about where you want your stuff to go to when you pass away. Now, if you don't have children, you don't have obvious heirs, or maybe you don't even like your children. Either way, you get to decide where your stuff goes, as long as you plan ahead. And so if you want certain nieces and nephews, certain cousins, or if you just want it to go to charity, you want to make sure that you have a plan in place. And mostly, you want to make sure you have a plan in place so it's easier on everybody else, because it really becomes hard in an estate plan that's not there when there aren't children, when there aren't default people to leave things to. So your family, like, it's a unique situation that families really don't know about. And you want to make sure you have a plan in place with instructions in place on how you want your assets to go, where you want them to go, whether they go to charity or that one niece or all the nieces and nephews or the uncle or the brother or the sister, whoever you want to go to, you get to choose. And it's your inheritance. It's your property. It's your assets. You get to choose. Nobody can tell you otherwise unless you don't plan. So again, make a plan, look at disability, look at who you want to leave your stuff to, but make sure you get it down and make sure you talk to an estate planning attorney and make sure you get somebody to help you plan ahead of time while you're alive and well for all the stages of your estate. So again, I'm Raymond Chandler with Polaris Law Group. We're estate planning and elder law attorneys out of St. Charles, Missouri. We'd love to be able to help you with anything we can.